Right, everybody's coming in now, so that's wonderful. So thanks and good afternoon, everybody. Welcome to the Greater Birmingham Transatlantic Chamber of Commerce event this afternoon, which is very kindly being sponsored by Birmingham City University and the Centre for American Legal Studies. So what we wanted to try to do with the webinar this afternoon was give you a real understanding about the process of the US elections, because if you're anything like me, there's so much complexity around it. I really wanted to understand how it all worked, and that's where this webinar came from. So just so that you're aware, we are very tight on the time, so it's from 4 till 5 p.m. today. And so we're going to get through some introductions of everybody. And we have, starting our speaking, we will have Professor Luke Mason, who is the head of School of Law at Birmingham City University, followed by Dr. Anne Richardson Oakes, who is the director of the Centre for American Legal Studies at Birmingham City University. And then Dr. Oakes will be introducing all of the speakers for this afternoon. And we're hoping to finish the speaking slots by about 4:45, 10 to 5. And then what we will do is have a very brief Q&A session. And any questions that we don't manage to get through this afternoon, we will certainly pick up on them and we'll send the information out to you afterwards. If I can ask you to put all of the Q&A into the Q&A box, I will scan the chat as well, just in case, and we'll facilitate the question and answers at the end. Grace, would you mind moving on to the next slide for me, please? Because I just wanted to take this opportunity as well of telling you about next week's event through the Transatlantic Chamber, which is also being sponsored by our wonderful partners at Birmingham City University. And that is the US elections post-election reaction breakfast. So we held this event 4 years ago, and we had some really interesting speakers on that morning. Giving their reaction to when President Trump got into power. So we're hoping for exactly the same next week. And if you haven't already registered, then please do. We have the link on the website for you to sign up. So that will be an early start though. That'll be an 8 o'clock breakfast event. So without further ado, for now, I'm going to hand over to Professor Luke Mason, who is head of the School of Law at BCU. Over to you, Luke.
Thank you so much, Mandy. I'm going to speak for a mercifully short period. I just wanted to thank everyone who's been involved in the organisation of this event, bringing together the Chamber and, of course, our centre at BCU, which we're incredibly proud of and which Anne will say a few words about in a moment. In just doing this, I wanted to share a few thoughts about why this is such an important event. So in theory, my title is Professor of Jurisprudence. So I'm a Professor of Legal Philosophy. And I wanted to just share a couple of words about why I think it's important that we are here talking about this, an election amongst lawyers, and why lawyers are an interesting perspective, why lawyers have an interesting perspective on this. Usually, of course, we think of politics and elections as something divorced from law. The ability of communities to make their decisions based on other matters that then maybe become law or add to law. But things are more complex, as we know, in the United States at the moment. And it's often said to be a truism in legal theory that constitutions and constitutional law and politics are the same thing. And that often strikes us as strange because we have historically well-functioning democracies, constitutional democracies, such as the United States, which demonstrate that that doesn't always have to be the case, that where people agree about the rules of the game, we can have politics and we can have law, and we can have both of them functioning exceptionally well. And I would say America is the greatest historical example of that, when things function perfectly. And you might see where I'm about to go with this now. What we have at the moment is an election in America where it's not only that there are players in a game who disagree about the tactics to pursue or the styles to play according to, but disagree about the rules and who are playing a game according to perhaps contested rules, or deliberately playing with those rules. And of course, when you have an election based around contested rules, sometimes we call this a constitutional crisis. And what you need to understand it are people who understand how to explain rules and deal with rules and understand that election through those rules. And of course, those people are lawyers. And I'm really glad we're kind of able to bring together some really august minds to frame this discussion through law. And what better place, what better forum to do that, I guess, than here. And also, of course, through the Centre for American Legal Studies at BCU, which is, it's no exaggeration to say, it's the most august seat of learning for American legal studies within the United Kingdom, and one of the leading centres for of knowledge in American legal studies outside of the United States. So it's with great pride, which I'm going to pass on to my colleague Anne, who was the founder of that centre and is the director of that centre, who can say a little bit about it and can coordinate the discussion on this. So I'm going to pass on to my friend and colleague Anne, and I'm really looking forward to the discussion and looking forward to learning a lot.
Okay, thank you very much, Luke. Thank you for that introduction. So we're absolutely delighted at the Centre for American Legal Studies to be partnering with the Greater Birmingham Chamber with this special event in, I suppose we can call it a special year, but it's actually also a very special year for our centre, because although we were established in 2010 as a research centre, our roots go much further back, and they go back to our US internship programme, which pioneered practical lawyering when we sent out law students to assist underfunded death row defence attorneys in the United States. And our internship programme became the largest student internship programme of its kind in the UK. Our first intern went out 25 years ago, and so we're celebrating our 25th anniversary this year. A celebratory event is planned and will take place, but for obvious reasons, it's currently on hold pending resolution of the current situation. But what I would say is just watch this space. So as a research centre, we have an extensive research profile and a range of interests that extend not just to the United States, but to the wider Americas, with a growing interest in the legal and constitutional structures of the countries of Latin America. We very much retain our commitment to our internship programme, and we support our students with a suite of modules which prepare students for US legal study. And first and foremost, of course, and in order to do that, we have to introduce them to that iconic document, the US Constitution, which is over 200 years old, but which put in place the structures and principles of government, which by and large continue to this day. Now, I called it iconic. It's written in 1787, ratified in 1788, in operation since 1789. The US Constitution is the world's longest surviving written charter of government, and it begins with these very important three words, iconic three words, we the people, signifying that the government of the United States exists to serve its citizens. But when those citizens are divided by political polarization and partisanship, as they are today, the integrity of constitutional mechanisms as guarantees of democracy is called into question. So next week, the world will be watching US democracy in action as the nation goes to the polls to elect its president for the next 4 years. Also up for election are all 435 seats in the US House of Representatives and 35 of the 100 seats in the US State Senate. The US Senate. At state level, we have 13 state and territorial governorships in play, as well as numerous other state and local elections. So this much we know. But the mechanics of the US electoral process and the roots of the controversies that surround it represent, it has to be said, something of a mystery for many observers on this side of the Atlantic. So with us today for a beginner's guide to the US elections, we have a panel of 3 experts who are going to help us unravel some of the complexities and controversies and to answer some of the questions that you might want to raise via the chat box as we go through. And first up, our first speaker is Professor Philip Davis. And Professor Davis has published extensively in the fields of American studies and US politics, with a particular interest in US elections. He studied and taught in universities in the UK and the US, including 1 year as a Fulbright professor. He's served as president of the European Association of American Studies and is currently co-chair of the American Politics Group of the UK. He remains Emeritus Professor at De Montfort University and is Director Emeritus of the British Library's Eccles Centre for American Studies. He's a Distinguished Fellow at Oxford University's Rothermere American Institute, and he's going to start us off with an introduction to the electoral process and the mysteries of the Electoral College. Professor Davis.
Ladies and gents, can you see my screen? I don't know.
Not yet, Phil.
I'll share it for you now. I'll just grab the slides. 2 moments.
Go on.
Got it.
Thanks. Great. Ladies and gents, Grace, do I have control over this, or do you? This screen.
I'll do it for you. Just let me know when you want to go to the next slide.
Thanks, that's good. Yes, ladies and gents, sorry about that technical hitch. It's typical of my relationship with the modern world. Recent history. What we've seen in the last election, as you can see on those figures there, is that Hillary Clinton received about almost 3 million votes more than Donald Trump, but Donald Trump won in the Electoral College. And just a few years before, in 2000, a similar thing happened to Al Gore, who received 500,000 more votes than George Bush, but lost in the Electoral College. It was a much closer deal. In fact, the mismatch between popular vote and the Electoral College vote in 2016 was the biggest that's ever happened. But well, let's go backwards. As Anne said, the Electoral College is part of the US Constitution, which was written in 1787. And the Constitution was written by a group of men who were not, in any 21st century sense of the word, Democrats. They were, you can give them credit for forward thinking, particularly for the 18th century, but nonetheless, the Constitution was a document that didn't recognize Native Americans or women as full citizens, counted slaves, incorporated slavery and counted them as 3/5 of humans. This is not a document you might expect to have a provision for direct democracy. So the Electoral College was designed at the most as a kind of form of indirect democracy, and as a way, indeed, along with some other things like separation of powers, checks and balances, of checking the mob, as well as protecting against a cabal. So the idea was that a group of men, was all men, chosen by each state individually in a manner decided by that state, would take part in the choice of the president on behalf of that state. It was adapted almost immediately because the Electoral College almost immediately led to presidential election crises in the late 18th century. By 1804, 12th Amendment. But since then, it's remained structurally relatively untouched, though it has been affected by non-constitutional amendment changes for the most part, increases in the popular vote, and also an increased reliance on popular vote, because initially states did not use the popular vote to choose their electors, whereas by the Civil War, or by the end of the Civil War, they all did, with South Carolina being the last one to join in this extension of democracy. Can we have the next slide, please? The structure then, which was established then and which remains roughly the same now, is that each state's electoral college vote equals that state's number of US representatives plus that state's number of US senators. So that gives some extra weight to the small states because it gives this, if you like, at large extra 2 votes, the US representative US senators to each state, regardless of size, whereas the rest of it is predominantly judged by size. The 23rd Amendment did add 3 electoral college votes for the District of Columbia, which didn't have any representation in the electoral college before that because it's not part of any state. So what you have now is that the lowest population states listed there each have 1 US rep, 1 US senator, and therefore 3 electoral college votes, whereas the largest state, California, has a total of 55 electoral college votes, and the other states spread along the spectrum between those according to their size. Now, in basing the number on the same number as representatives and senators, they're not the same people. We mustn't mix those 2 things up. Indeed, all federal office holders are prohibited from being members of the Electoral College. It's supposed to be a separate body of good persons and true, so to speak, who will choose the president on behalf of their states. So the total membership, nonetheless, still we can go back to these models, is 538, made up as it shows there. And to win the presidency, you need an absolute majority of that, which is 270. So 270 electoral college votes you need are based on what's going on in each state. Could we have the next slide, please, Grace? Thank you. So bringing it up to date, how does this process work in 2020? Well, the popular vote in each state is to determine which presidential candidate which will gain that state's electoral college votes, except that the state legislature still has the absolute right to choose the electors. So there might be some dubiousness in that, but fundamentally that's the way people expect it to happen. States traditionally, it's not by law or anything else, but traditionally they've developed the idea of delivering 100% of their electoral college vote to the popular vote winner in their state. And the reason they do that is they think that will increase the state's weight in the national election rather than dividing it between the 2 parties. 2 states do divide their electoral college vote up, Maine and Nebraska. And as I say, states still appoint electors in whatever way they choose. And many now require electors to support the popular vote winner. But electors who vary from the popular vote winner, which is allowed in some states, are called faithless electors. There were 7 in 2016, the largest number ever. Most of them defected from Hillary Clinton. In a close election, technically, faithless electors could swing an election. It's never happened, but it's always one of those things that academics and journalists love looking at the tea leaves about, just in case it adds some excitement to the election. So the popular vote in 2020 will close on the evening of Tuesday, 3rd November. Electors will meet in their states. They never meet together as a body in mid-December to cast their votes. The votes are validated by the states and sent to Congress, sent to Washington, where the vice president in front of Congress opens them next year on 6th of January to count them. And these are usually uncontroversial ceremonials nowadays that follow the election. But if faithless electors, if enough faithless electors emerge to change the result, then it becomes controversial. And also, if, as some people have suggested, states committed to one candidate might instruct their electors to vote for that candidate regardless of the popular vote, then it could become very controversial indeed. Could we have the next one, please? So the popular vote and the electoral college vote rarely disagree. They disagree in proportion. So before 2000, only 3 times those dates, and you could even dispute 1824 in that the popular vote wasn't widespread at that point. most often the Electoral College has exaggerated the popular vote, and people have considered that to be bolstering a system in which a close vote might lead to national political difficulties or social difficulties. But in recent years, an era when national votes have been close, political divisions have become increasingly bitter, there seems to have been rising anxiety about any possible misfit, particularly as we've had two recently. And political cultures in the US differ regionally. It's a huge country, 360, 380 million people, divided in 50 states plus the district, with hugely different economic rationales, different industries, populations, subpopulations, say, you know, of African Americans or Latinos, Southeast Asians, not distributed evenly across the country, whites not distributed evenly across the country, and so on. So interests differ in different regions, which means that one party might have great strength in some areas, not in the others. And therefore, you get the situation where either party, the two major parties, sorry, we're ignoring the minor ones, but either of the two major parties may rack up huge majorities in some parts of the country, and whereas another party might be winning efficiently in a number of states. And so you do get the situation where the popular vote can be, if you like, distorted somewhat by the Electoral College. It was entirely expected by the founders, who, as I say, they were looking at a two-tier democracy, a way of choosing by, if you like, a higher class of mind. So, in the situation in 2016, for instance, Clinton, who racked up a huge majority in California, as opposed to Trump, who got smaller majorities in a large number of states, it cost her a campaign about 300,000 votes, 290,000 votes for each Electoral College vote, where Trump was achieving them at just over 200,000 votes for each Electoral College vote. And people get upset if that happens too often. It's not gerrymandering, it's the way that current voting groups map onto the Electoral College, and it can change. But estimates do suggest that at the moment that unleveling, if you like, of the playing field makes it more difficult for a Democrat, so that it probably needs about 4% of the 4% lead in the popular vote to guarantee an Electoral College victory. Could we have the next one? So how do campaign managers respond to this in 2020? Well, they use evidence, they identify the minority of states in play. You say, which states are we definitely going to win? Which states are they definitely going to win? The other states are in play. That's where we will put our resources. They design a campaign to win the popular vote in those combination of states, the ones we're definitely going to win, the marginal ones. They look at the routes to 270 votes, adding up the different states to do it. So it's a kind of an exercise in mathematical geography overlaid by political ideology and issues. They monitor closely which states are in play, because they can shift as issues happen. And remember Clinton's mistakes in Michigan, Pennsylvania, and Wisconsin for next year. So they have to respond that. Now, this pattern, this strategic pattern, if you like, remains the same in every election. But issues change, voting groups grow and decline and migrate. Political agendas shift, and campaigns are differently successful at projecting their candidates. So the actual places you're campaigning may differ over time, but the model of the strategy doesn't change really very much at all. You always have to be aware of, if you like, the political geography of the Electoral College. Next slide, please, Grace. Thank you. What was brought into focus, amongst other things, by the 2020 campaign? Well, one, a breaking issue can completely change an election. COVID certainly did. There's always an attempt particularly by incumbent candidacies, to spring an October surprise, to throw something in because they're the executive, that might destabilize the election in their benefit. And of course, the FBI statements in 2016 were one aspect of this. Second, it's the Supreme Court, stupid. Those of you who are as geeky about US elections as I am will recognize this as a corruption of James Carville's "It's the Economy, Stupid" statement for Bill Clinton. Well, the National Organization of Women picked up on that. And I think it was in 2004, started producing buttons saying it's the Supreme Court, stupid, because they were concerned about the impact of the Supreme Court on the legal situation over abortion and other issues that particularly affected women, and trying to energize women to vote because of the potential of a problem with the Supreme Court. This time, that's been so enhanced by the midterm nomination battle over Kavanaugh and the contemporary battle over Barrett. And the issues that will come out of that for years and years. Next one, and alluded to this, there are 500,000 elected offices in the USA, and we do talk about the presidency an awful lot, but actually most domestic spending on domestic policy, the majority of domestic spending on domestic policy in the USA happens at the state level, not from the national government at all. So those other elections are very important. Next, 2021 is going to be hard for whoever is elected for all kinds of reasons. And lastly, since I've made the Electoral College so central to this and pointed out the ways in which it intervenes, if you like, in the election, nonetheless, don't expect it to disappear. It's much too difficult to get rid of it. Thank you.
Thank you, Phil. Thank you very much. So there will be questions in the chat box, please. Our next speaker is Professor Laurie Ringhand. And Professor Ringhand is Professor of Law at the University of Georgia School of Law and Interim Director of the Dean Rusk International Law Centre. She is a nationally known Supreme Court scholar and the author of a book, Supreme Court Confirmation Hearings and Constitutional Change. She's taught in German and Israeli universities, and last year spent a semester as a Fulbright Scotland visiting professor at the University of Aberdeen, where she also found time to come and visit us at Birmingham City University. So we're very pleased to see you back, Laurie. Professor Ringhand holds a Bachelor of Civil Law degree from the University of Oxford and has been a visiting scholar at the Oxford Institute of European and Comparative Law. And she's going to talk us through some of the issues relating to electoral fraud and the controversies surrounding voter disenfranchisement. Thank you.
Thank you, Anne, and thank you to the Center for having us here today. I assume you were able to see my shared screen? Yes?
Yeah.
All right, and I apologize for bouncing it around a bit. So the first thing I want to just frame this topic of fraud and suppression in the U.S. election. As you all are undoubtedly aware, there has been an unprecedented uptick in stoking of fears that the election will somehow be unfair. And what you see on this, it's a NBC poll from August, is that agitation has been disturbingly successful. Doing a bit of math here, among self-identified Republican voters, 65% are not confident that the election will be fair. That number is 56% among self-described independents and 46% among self-described Democrats. And those are numbers of people who express a lack of confidence that the election will be conducted fairly. That is deeply troubling. A peaceful transfer of power depends on people believing that for the most part, the elections were accurately capturing in a fair and sensible way the intentions of the voters. So we are in unprecedented territory here with these numbers. So I'm going to talk briefly today within my allotted time to really do two things. First, to perhaps offer a bit of reassurance about some of the stories spinning around that you might have been hearing over the last few weeks. In other words, about what's happened to this point. And then lastly, perhaps be a bit more pessimistic about what you might see next week. So to start on the slightly optimistic side, to understand a lot of the contests that you're hearing about US election rules, things like how voters get their ballots, how they return them, what criteria they have to comply with when fulfilling them. I think understanding those disputes really requires understanding three core facts about the US system. The first in our circle here is that the US system is radically decentralized. We do not have a election system. We have 51 election systems from the states and the District of Columbia. And all of those jurisdictions, I'll call them states for ease, they make their own election rules with very few federalized restraints or restrictions. So the nuts and bolts of election, whether you have to register in advance, whether you register with a party, whether you can cast an absentee ballot, whether a vote by mail ballot will be automatically sent to you, how you return that ballot, how you prove your identity when you are in the act of voting. All of those questions are functions and matters of state law. So they will differ across the states. And that's by design, that when you're hearing things that seem contradictory, it is often because what you are looking at are interpretations of rules from different states. And secondly, those state rules and regulations, those nuts and bolts about how the elections work, they differ not just in substance. Do you have substance, for example, meaning do you have to return your ballot by the date of the election, or does it just have to be postmarked by the mail service by that date? So there's substantive differences, but in the rules and regulations, but there are also differences among states about who has discretion to make the rules within the state. So for example, when the governor of Texas decides that there is only going to be one drop box, a place to deposit your ballot in advance per county in Texas, the question there, the legally relevant question is the governor the entity under state law who has discretion to make that decision, or is it the Secretary of State, which is the elected office in the US states who manage the elections within the states? So these state laws differ both in substance, but they also differ in questions of authority, who gets to decide. And a lot of conflicts involve those types of differences. Second important thing to understand what's going on with our election spats right now, there's no explicit federal constitutional right to vote. Unlike most democratic constitutions, the US Constitution does not give people a right to vote textually or explicitly. Instead, we have two corollary rights. We have anti-discrimination protections. There are grounds on which you cannot be denied voting. So if a state extends the votes to some people, it cannot fail to extend the vote to others, for example, on the count of race or age over the age of 18. So there are anti-discrimination provisions, even if there's not a explicit actual right to cast a ballot in the first place. Secondly, there is an implied right to vote under what is in US constitutional law called the Fundamental Rights Doctrine. This is a doctrine grounded in liberty and due process. It sources some of the more contested rights that the US Constitution and the US Supreme Court have enforced. It's also the source of a federal right to vote of some sort. But, and this is the third bullet point, it's a relatively weak right because the system delegates to states the power to make most nuts and bolts type of rules about voting. The federal constitutional implied fundamental right to vote is not absolute. It can be infringed, it can be burdened by state level rules that are not intentionally discriminatory and that do not impose severe burdens on voting. So in order to activate a federal constitutional claim, you have to either have been intentionally discriminated against in a way that's prohibited by one of the anti-discrimination provisions, or a state law has to be severely burdening your ability to cast your ballot. Those are fairly tough standards, and we don't see a lot of constitutionalization of voting rights because of this. Third critical fact to understand, and this is specific to what we are seeing right now. What we're seeing right now is that the US Supreme Court, when you hear all of these opinions about the court's shadow docket and what they are and are not permitting or holdings about various aspects of voting rights claims, there actually is a coherence to what the court is doing here, rightly or wrongly. So what we're seeing is that the Supreme Court has been very unsympathetic to claims that states should be required by federal law under the fundamental rights doctrine, the burdensomeness. The court has been very reluctant to it's been very skeptical of claims saying that states should be required to loosen existing rules in response to COVID. So the way that works, the way that maps onto what we're seeing happening here, just for a few examples. So for example, in Mississippi, not a swing state, the state legislature of Mississippi, the legislature itself made changes to make it easier to vote in response to COVID. That's fine. The Supreme Court has no problem with that. The states are the repository of rulemaking power. When the state legislature advanced a loosening of the rules, the Supreme Court had no issue with that. On the other hand, in the news out of Wisconsin, just these last few days, you might have seen, my beautiful home state, by the way, the Supreme Court has been deeply skeptical of changes like is what we saw there. The state legislature did not vote to change the rules and regulations about when mailed-in ballots have to be received. Rather, we saw a federal court a lower federal court under the fundamental rights doctrine order the state to extend its deadlines. The Supreme Court is not having anything to do with that. There is no sympathy for arguments that the federal constitution plus COVID requires states against the intentions of the state legislature to expand or loosen voting rules. So those have been pretty consistently rejected as affirmative claims by the Supreme Court. And then lastly, in the big question mark here, the court is very deeply contested. It's very torn up about how to handle changes made by state courts interpreting what state constitutions require. Unlike the federal constitution, many state constitutions do include an affirmative right to vote. And when state Supreme Courts are ordering legislatures to expand voting rights or loosen voting rules because of the intersection of COVID with existing rules, that's what's happening in Pennsylvania, and that's where we see the most contest on the Supreme Court about how they're going to handle those questions. So my takeaway point here is, I think for what we've seen so far, there is a order to what the Supreme Court is doing. They are allowing state legislatures to make changes to loosen regulations. They are skeptical of federal courts ordering state legislatures to do that. All of this pre-election stuff, I think, is it may evidence some room for activism at the state level to get states to change these laws, but legally, I don't think it's extraordinary. And we'll now move to my little bit of pessimism before ending. I'm a bit more concerned about what happens after the election, and what we're starting to see. There's a case coming out of Nevada where you're starting to see activity to invalidate legally or invalidate already cast ballots on the grounds that the voters didn't comply with something like signature matches. When that type of litigation happens after the election, when everyone knows what the partisan consequences of it are going to be, then we're in Bush v. Gore territory from 2000, and I think that gets much more fraught for the Supreme Court. And I will leave it with that, and I'm happy to take questions in the Q&A.
Thank you very much, Laurie. And we'll come back to questions at the end, and I'm sure there will be some. So our next speaker is Professor Bennett Gershman. And Professor Gershman is a founding member of the law school faculty at Pace University in New York, and he's a visiting scholar at Cornell and Syracuse law schools. He lectures and he writes extensively on prosecutorial and judicial ethics and misconduct, constitutional law and criminal procedure, and trial practice. And he's going to take us through today some of the issues relating to the recent nomination of Amy Coney Barrett to the United States Supreme Court, and the way in which these issues might play out in relation to this election. Thank you, Bennett.
Hello, thank you very much for inviting me to this important program. On September 18th, Supreme Court Justice Ruth Bader Ginsburg passed away. Justice Ginsburg was one of the most famous jurists, one of the most famous women, I think we can say, in America. She was revered for her humanity, her wisdom, her courage in battling health problems for many years. Justice Ginsburg was the first woman to lie in state in the US Capitol. Before she was buried, President Donald Trump nominated Amy Coney Barrett to replace Justice Ginsburg. There couldn't be more of a polar opposite between Justice Ginsburg and Judge Barrett. Justice Ginsburg was a great liberal. Judge Barrett is as conservative as they are. She clerked for Justice Scalia, and she's taken strong positions. Probably she would be the most conservative justice on the court. Justice Ginsburg believed in strong reproductive rights, the rights for women, minorities, transgender people. Judge Barrett, I say judge because she's sitting on the Seventh Circuit right now. I say Judge Barrett has taken positions against reproductive rights. Judge Barrett's philosophy is something called originalism, which I think is a kind of a fraudulent theory. She believes that the Constitution should be interpreted as it was written 240 years ago, when there was no internet, there were no public health programs, there was no public schools, when in the Constitution, only a man can be elected president or vice president of the United States. So if you're an originalist, the text of the Constitution controls. And of course, Justice Ginsburg believed in the evolving nature of the Constitution. Anyway, the problem with this nomination is that 4 years ago, when President Obama nominated Merrick Garland to replace Justice Scalia, who had just passed away, the Republicans said, no, you can't have a confirmation process between now and the election, which is 9 months away, by the way, because we should allow the next president who's elected, to follow the will of the people in appointing a Supreme Court justice. Now, Article 2 of the Constitution gives the Senate the power to appoint to confirm a president's nominee to the federal courts. And the Republicans boycotted the nomination of Judge Garland 4 years ago. And today, well, I guess the shoe is on the other foot. Now, those same Republicans who didn't want to even hold a hearing for Judge Garland as President Obama's nominee, now they want to rush through the process and make Judge Barrett a new Supreme Court justice to replace Justice Ginsburg. And in fact, they last Monday, they did confirm Judge Barrett to the court. She's now sitting on the court as we're sitting here right now and deciding, among many other kinds of cases, election cases. And it was clear that when President Trump nominated Judge Barrett to the court, he said specifically, I want this person to be on the court to decide election cases. And the confirmation process was something of a charade. Judge Barrett wouldn't commit to a position on reproductive rights for women, even though she has already written strongly against Roe v. Wade, the famous abortion case. She wouldn't commit on the Affordable Care Act, even though she's written against the constitutionality of that act. In one really troubling interchange with a senator asked Barrett would she commit to the proposition that there must be a peaceful transfer of power after an election? And I think many of you may know that Donald Trump has said that he would not commit to a peaceful transfer of power. He didn't answer that question. And Judge Barrett ducked it also. She said, well, it's a political question and I don't want to express a view on it. I mean, nothing could be more fundamental to our constitutional democracy than a commitment to a peaceful transfer of power, which Barrett wouldn't do. Anyway, should she recuse herself from election cases? Because it seems that the president and the Republican senators want her there to be deciding these election cases, which Professor Ringhand has just talked about. She should recuse herself because clearly there's a serious risk of bias here, even unconscious psychological biases. You know, human weaknesses are such that would she rule in favor of her benefactor, the person who nominated her? They just stood together last night on the presidential balcony in the White House after she was sworn in as a justice. I mean, the ceremony was really embarrassing. And so should she recuse herself? Of course she should. But she won't, I don't think. And she'll be sitting there on the court deciding election cases. And of course, we all expect that if the election is close, as it might very well be, which way will the Supreme Court go if they have to decide a case in the same way that the Supreme Court decided Bush v. Gore 20 years ago? And that's what's troubling so many people today, because, you know, people worry about whether there'll be violence on election day, and we really don't know, and we're terrified of that prospect. But even if there's even if it goes smoothly, there are going to be challenges. You know that if it's close, certainly Trump is going to challenge the results, because according to President Trump, the only way I can lose is if the election is a fraud. He said that. It's only if they cheat will I lose. So if there is a challenge, and if the case goes to the Supreme Court, you know, you really have to really worry here. Just this week, Brett Kavanaugh on the court said, we really think that mail-in ballots cause chaos. We're suspicious of mail-in ballots after the election, even though they were postmarked before the election, because he said mail-in, it could flip the election. In fact, what Justice Kavanaugh said in a footnote to the Wisconsin case, which Professor Ringhand just mentioned, it was almost an echo of what President Trump said about the mail-in ballots and about how the election could be flipped if we count those ballots. So, you know, we're watching, we're waiting, we're worrying. And, you know, people use terms like Armageddon, apocalypse, catastrophe in seeing what might happen next week. I think we do have to worry whether or not our Constitution and our democracy will survive. And I don't know that that's an overstatement. But anyway, that's my quick take.
Bennett, thank you very, very much. So we've got three very interesting, illuminating speakers that have raised a number of issues for us. We now have time for questions and answers. Mandy, I think, is going to host these. So I'm going to hand you back to Mandy for the remaining few moments of the session.
Thank you, Anne, and thank you so much, everybody. It's so insightful to hear all of that, and such a lot to take in, that I'm really pleased that we have recorded the session, and we will be able to upload this to YouTube before, you know, the election takes place, so people can really download all of the information that you've shared with us today. There's one question that has come in, which I think could probably go to all of you, and it's about, do you have any ideas on how to improve the electoral procedure where you believe that that system is lacking? And so I think you've all touched on areas where you've been presenting, but would one of you like to take a hold of that question and share where you feel that it's lacking and that some improvements could be made?
I'll have a go if you like. It's a difficult question because it is such a complex system, and it involves not just complexity of today, but a complexity of American history, the belief in such principles as federalism and checks and balances and so on. So merely to say, well, it should reflect absolutely the popular vote, ignores a lot of that history. Perhaps it should be ignored, but that's a long debate for Americans to have, not for outsiders to have. And there is also another problem in that it certainly gets tough when electoral college votes get very close. But what about if there's a national election and then it comes down to 50,000 votes or something like that? It did come down to, in 1960, it was very close to that kind of figure, about 200,000 votes, I think. Then people could be equally stressed, equally could use it as a way of the populist advancement of conspiracy theories. So great difficulty. There are a couple of attempts to. We'll never get a constitutional amendment, certainly not in the near future. It's much too difficult. But there have been suggestions that groups of states who committed to casting their electoral college votes for the national winner would have such a strong impact that would make the election fairer. There are also suggestions should increase the number of people in the House of Representatives because it's not been increased since the 1930s, and that would increase the number of electoral college votes and also distribute them rather more equally, rather more according to population. They're all nice ideas. They're great academic points, terrific for debating, most unlikely.
I would like to see more federalization of election procedures, things like uniform registration rules, uniform rules about ballot deadlines. What I'm seeing in kind of the blog comment sphere right now, there's just such deep misunderstandings or lack of information about what it is even going to mean or represent when ballots are not fully tallied by election night, which in many states, like Pennsylvania perhaps being the most critical one, under state law, the election counters are not even allowed to open and begin processing and verifying mailed in ballots prior to when polls close. So rules like that and the fact that they are so different across the country, I think generate a great deal of confusion about what is actually going on and that these are perfectly valid and legal votes within the state in which they were cast. They just have not gone through the counting process yet. That opens the door to all kinds of misinformation. So I would like to see more uniformity around those types of registration and deadlines. I also think the one of the most critical things that we could do that would still be consistent with the federalism norms that Phil talks about, which are of course very deeply embedded in our way of thinking about these issues. Secretaries of State, which in each state in the US, they are almost always the primary elected, they're the primary official dealing with administering elections. And they are elected office holders elected on partisan ballots in most states. That is deeply problematic. I think our secretaries of state have done an excellent job. They are all in this job because they care about the democratic process and they're trying to make very sure that their state's rules work and function properly. Once the election results are coming in and you get to fights about particular ballots and whether particular ballots should or should not be counted and what happens as results start coming in, the appearance of partisan self-interest, even in the absence of its actuality, is deeply troubling and does not instill people with confidence in the system. So those should not be elected offices. Ideally, we should not have elected officials in charge of overseeing elections, or at least they should not be elected on partisan ballots.
Thank you, Laurie.
I have nothing to add to that.
Thank you. Thanks, Turan, for the question there. And the next question is from William Horncastle of University of Birmingham. And William's asking if you think that the process for appointing Supreme Court justices is undemocratic And if so, how could this process be improved?
Well, you know, in a dictatorship, the people who hold power can do whatever they want to do. In a democracy, the people who hold power can do whatever they want to do. And the Republicans in the Senate have shown it by boycotting President Obama's nomination and by rushing through Barrett's nomination. I mean, but again, it's part of our political process. The party that holds power can make these kinds of decisions. You know, one of the questions people are raising right now is whether or not Congress, assuming that President Trump loses, assuming that Congress becomes Democratic, whether or not they'll pass legislation to add justices to the Supreme Court. Now, this is one of the most controversial questions that we face historically, because President Franklin Delano Roosevelt wanted to pack the Supreme Court. It didn't get far, but it caused a great deal of huge, controversy. But it seems to me that many Democrats are poised to do just that if they gain power. And to add 5 or 6 justices to the Supreme Court is something that Congress could do, because the Constitution says nothing about the number of justices. We've had 4, we've had 5, we've had 10, we've had 7. And so it's stuck at 9 since Ulysses S. Grant. But could Congress do it? Yes. Should they do it? I would just say we'll see.
I would add to that, I think it's helpful to remember that the Supreme Court is within our systems of checks and balances. It doesn't exist outside of it. And of course, the court's most famous checking role is its ability to exercise US-style judicial review and declare the acts of legislative bodies unconstitutional and therefore void. That's how the court checks the other branches. But the constitutional design itself also includes ways for those branches to check the court. And one of those is the political nature of the appointments process. The appointments process runs through elected officials. That functions as a check on the long-term direction of how the justices exercise the discretion that the open-textured phrases of the Constitution leave to them. As Professor Bennett mentions, there are other checks that the Constitution enables the elected branches of government to exercise. The Constitution allows Congress to control, to some extent, the jurisdiction of the Supreme Court, and of course, the number of justices who sit on the Supreme Court. All of those tools have been used historically. There is nothing anti-constitutionalist about them. They're right there for the Congress to use. And I don't think we should be surprised in an area of polarization and gaming of the court if a future Congress exercised some of those checking powers.
Thanks, Laurie. I'm just going to go down a few of the questions now. I know that we are getting to 5 p.m, so just a really quick one from our president, Steve Allen, actually, saying that there are so many talented people in the United States, and it was clear from watching the primaries that there were a lot of younger, highly capable politicians out there. And Steve's asking the question about the age of the 2 candidates that we have on offer there. The president, who's 74, and the vice president 77, isn't the whole process far too dependent on money? Would anybody like to pick that one up?
I'll have a quick go. Yes, there's an awful lot of money involved, and all attempts to control that have fallen apart. In the early 70s and through the 70s, it looked as though there was an opportunity to at least limit that, but it's the limits that were introduced have gradually been blown away, in part by Supreme Court decisions. The Supreme Court is a phenomenally political institution in terms of its impact, whether justices make their decisions on political ideology or not. The impact is still political. Yeah, there were a lot of interest in candidates in the early days of the primaries. I was in Iowa, I was in New Hampshire. I met, I think, 23 different candidates, but most of them had no chance whatsoever. They were in it for some other reason. They were in it because they hoped that whoever one would give them a nice position in the cabinet or some other thing. The actual number of strategically placed, potentially successful candidates was very small. And it was rather disappointing that there weren't strong, because we're only talking about Democrats. There were people opposing Trump as well, but they were rather they were not strong candidates. I'll put it that way. In the Democratic Party, it was rather disappointing that really strong candidates who had enough track record to push them to the front. There wasn't a large body of them, if you looked at it. It was interesting, however, I thought that of the first, I think, 5 candidates to declare, 4 of them were women. And I did wonder whether after the 2018 midterms and after the rise in women's political feelings and activity in response to Trump's election, this might be the year of the woman, not 2018, not 1992, but now. And that wasn't to be. But of course, the Biden ticket, the Biden-Harris ticket, has the potential to make that part of the future.
Thank you. And we are sort of reaching our time limit now, really, of the webinar, and we do still have various questions that haven't been answered. So what we will endeavour to do is send those out to our speakers and get those answers back to those that have asked the questions. However, at the end, what I would like to do is thank everybody so much for what you have participated in today. And just as a little fun element to finish off, we thought that we'd just put a poll on for everybody who's participating. So all of the attendees to give us their view. So who do you think will win the US election? So come on, audience, this is your turn to participate. So if you can put your vote in. As panelists, we can't vote, I'm afraid. So let's just let the audience put that in. Grace, how's that going?
Just waiting for a few more to give it another 20 seconds.
And maybe after what you've heard today as well, that may have changed some opinions of people as to how they feel it will go next week. Yeah. Okay.
Right.
Shall we go for it?
Yep.
There we go. Okay, so from our audience today, any last minute comments that any of our speakers would like to make on that result?
Oh, well, we have to remember 2016. I think it would have come out very similar then. But I tend to go with the majority here.
I think you should have played the Oscars game. Who should win? Who will win? All the different gradations of the question.
Absolutely. Okay, anybody else? Okay, all right, lovely. Well, I would again just like to thank you all for what you've shared with us today. Absolutely fantastic. We'll make sure that it's uploaded to YouTube for everybody to absorb again. And don't forget that we do have another event next week, which is again sponsored by Birmingham City University. So please do tune into that. And on that, thank you, everybody. Unless Dr. Anne or Professor Luke would like to close off.
Well, I'd just like to say thank you. Thank you to all our speakers. And on the very last note about the distinction between who should win and who will win, I don't think we want to give any hostages to fortune.
Thank you. Okay, well, with that, I wish you all a good evening and thank you for participating in the Transatlantic Chamber of Commerce event on the US Elections Beginner's Guide.
Thank you.
Thank you. Bye-bye. Bye-bye, everybody.
Bye-bye.